I welcome you now to the second week of the course. I am Bharti, the Faculty Coordinator of Environmental Laws, Associate Professor at the National Law University, Delhi. In this week, we are going to look at two more modules, which are the human right to environment and the sources of environmental laws. When we talk about human right and environment, there is intrinsic relationship between the two, and this positive correlation translates into dignified life, into better global discourse on environmental problems and issues. Also, when we are looking at the constitutional narrative, it is important to understand that the presence of environmental provisions in the constitutions of the world set the agenda for the nation to look into greater details in terms of legislation and further interpretations on various complex issues pertaining to environment. When we are looking at sources of environmental law, it is clear that Constitution becomes the foundation, and further it is ably supported by legislation and judicial interpretation. In the Indian context, we know that the Constitution of India has included environment as a very important area which has been incorporated by the 42nd Amendment Act by virtue of Article 48A and 51AG of the Constitution, wherein the directive principle of state policy and the fundamental duty integrates this component effectively. There are other provisions of the Constitution too. For instance, Article 253, which enables the Parliament to make laws to enforce international treaties and conventions. Further, you find that Constitution of India then provides the benchmark and the starting point for enabling statutes and pronouncements, which in the Indian context have been many. So, the starting point of the statutes has been the Wildlife Protection Act, and thereafter there have been a spate of enactments, noticeably the Environment Protection Act of 1986, which came in the aftermath of the Bhopal gas disaster, and further we have many other legislations, including the Forest Rights Act of 2006, which is one of the more recent contributions. Apart from these, there are an array of rules, regulations, notifications and the like, which relate to different important aspects of environment. For instance, in respect to waste rules that have come up in 2016 and the CRZ rules which have come up in 2011, the notification that has come up in relation to the environment impact assessment, judicial activism also supported by NGOs and civil society groups has brought the cause of environment center stage. We find that through the route of public interest litigations, the court, especially the apex court, the Supreme Court of India, has deliberated and has focused attention on the issue of environment and has, through its very innovative, in a very innovative manner, it has propounded, say for instance, the absolute principle of liability, the absolute liability principle, the principle of continuing mandamus and so on, whence the whole issue of environment has been interpreted in a very interesting and a significant manner and has increased the myriad ways in which the sources of environmental law have been augmented for the present generation, for the present and future generations.